what next meeting they'll fit you in on.
Okay.
But hopefully it won't come to that, but we'll go on and see what happens.
Great. Okay, thank you very much.
Thank you for your patience and flexibility. Madam Clerk, would you call the next item?
Item number 5, file number 18079, complaint filed by Ellen Sang against Lily Magis and the Department of Building Inspection for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner.
And-
I don't believe the respondent is here. The complainant is.
Lily Magis is here.
Oh, okay. You're here. Okay.
Because my knee is in pain before OH, I asked you for permission to sit down and have my presentation.
Sure, you can speak at the ADA mic
I get the chair.
down there.
You help me to get the chair.
You okay?
As long as, Madam Clerk, you remember to turn that particular mic on.
It is on.
Okay. Okay, so what we do in this committee is we're not here to adjudicate per se. Our primary goal is a sort of a fact-finding mission of the case. So we determine jurisdiction, and then the records are public, and then we have sort of make sure all your records are gathered together and what you might need for a full case to go before the task force. We just want to make sure your file is as complete as possible before we send it up to the full task force. And I'd like to note that Member Martin has joined us at 5:40.
5:43 p.m. Yes, I made a
PM.
note.
Yeah. So, Ms. Zhang, would you like to start with
Yes.
5 minutes?
You have 5 minutes, Ms. Sang.
Okay, thank you. Good evening. My name is Ellen Sang. I make an immediate disclosure request for public record on August 16, 2018, which has 4 items. I request the responses by reference to my number requests. Only number 4 request is the subject of this complaint. Number 4 is for all correspondence between DBI staff for time frame less than 1 year and for 1 permit application at 1 location. In my complaint, I specified the location and the permit number, so I'm not repeating it now. Summary of the event. On August 17, Ms. Lily Magis, Communication Director, failed to produce any record. 11 days later, he requested me to pick up and pay for CD and claimed that all the responses were in the CD. On August 29, I went to DBI and paid for the CD. It turned out this CD has three items. The first one has 5,619 pages. The second has 4 pages. The number 3 has 7 pages, but without reference to my number requests. I request her to identify what specific pages are the responses to each of my numbering requests. She refused to answer. I request her to provide only the responsive records. Email has exchanged between us. But as of today, he still failed to produce responsive public record to my number 4 requests. He claimed that her responses to number 4 are too large. I have to go to DBI again to pick up another CD. He also claimed that one email he has withheld because he determined that it contained DBI staff privacy. He should not be the one who determined who to withhold email between DBI staff, who uses city time email address to conduct normal business. Since these are all emails, I repeatedly requested she forward or email these emails to me. She refused. After I emailed my supplemental on November 16 and November 20, this task force sent out the hearing agenda. November 20 was the first time I found out that she emailed over 100 pages dated October 31st, 2018 to you. But this over 100 pages are not the responsive document to my number 4 requests because they related to my other public record request. which are not the subject to this complaint nor today's hearing. This hearing is for my number 4 requests only. Mr. Magistrate intentionally trying to mislead you, the public, and me by email you over 100-page email related to other requests, but not for number 4 requests. You should not allow such wrongful tactic. Since she was able to email over 100 pages to you, she's able to email or forward me the 100 emails to comply with my number 4 request, but she has refused to do so. You should find violation against her and DBI and order her to email or forward me this 130 emails that she claimed is her responses to my number 4 request, and order her to produce the one email between DBI staff she has withheld. Thank you.
Okay, Ms. Magis, you have 5 minutes. Or you can use that one, it depends. Whichever one.
So I just go to the others? Okay, sure.
We'll call you forward if we have questions for you, Ms.
Can you move the chair?
Good evening, Lily Magis Wu from Department of Building Inspection. I handle sunshine requests for the Department of Building Inspection. We received a request from Ms. Sang on August 16th, an immediate disclosure request. That same day we responded and said that we weren't treating it as an immediate disclosure request because there were 4 different requests in her email, and thus we needed to go ahead and locate the documents she was requesting. In regards to item number 4, we produced it to her on August 27 with the CD. She did say that there was too many documents in there, so we produced. We informed her that there was another CD that was available that she could pick up. She didn't come by and pick it up, so I offered to send it to her in the mail. She asserts that I have refused to produce the documents to her. What we've told her is the files are too large. It cannot be sent via email. We've produced it on a CD. We've offered to give it to her for no fee. The documents that she's asserting that was produced to the task force was sent via inter-office mail. It was not sent via email, and I hope the clerk can confirm that with me, the fact that that occurred because the files were too large. Again, we've sent another CD to Ms. Sang with the documents in there. We've made attempts to produce the files to her. There has been no case of me refusing, although she asserts many times that I have. One thing I wanted to clarify was she asserts that we withheld a document. We did not withhold any document. We informed her that some of the documents may have been redacted and or withheld information due to privacy as allowed by Sunshine and public records requests.
Okay. At this time, do either of my colleagues have questions for either the petitioner or the respondent?
I did have one question of Ms. Magis. Just the last thing you were referring to there about the withholding or redacting. Are you saying that no documents were withheld from the production?
Correct.
Okay, so it was just a redaction issue.
Correct.
And, when you say
the wording
withholding-
was redacting/withholding, and she had asked about that, and I said there was no withholding, and I even reconfirmed that, and we just confirmed that it was a redacting of private information, a person's personal email.
Okay, and you did. Your all's position is everything has been mailed. The CDs have been mailed out. The documents
Correct.
are there.
Correct.
Okay.
Other questions? Okay, I have a question for Ms. Magis real quickly, and then I have a follow-up probably from Ms. Sang. So you did invoke an extension?
We, per our process for immediate disclosure requests, if it's not simple and routine and readily available, we treat it as a normal 10-day request.
That's interesting.
But we did respond right away to her immediate disclosure request, informing her that, and we did produce a response and the responsive documents to her within the 10-day allowable period.
Okay, Ms. Zhang, would you? Sorry.
First of all, immediate disclosure.
I had a question. I just want you to confirm that you were indeed notified that they were taking a 10-day extension.
She emailed to me 10 days.
So you were notified that they were taking a 10-day.
But the sunshine, as I know, in the past, the ruling is if there's an immediate disclosure, you have to produce some documents. You cannot produce none, and says I need the extension. But finally, the number one, she just produced one document, have 2 pages. Number 2 is this is 4 emails, 2 emails, 3, and the number 3 is the 5 emails.
Ms. Zhang,
so it's not,
you'll have time for your rebuttal.
Okay, I'm just saying that one of the documents, she says withholding correspondence that you had with the city employee, and then there's in many emails. I have not seen the number 4, but in the emails, she did the one available. It says that withholding correspondence you have.
I know.
So that's they will feel holding. She says this is a privacy. I mean, I have not seen anything she produces related to adapting anything.
You'll have time for your rebuttal in a second.
Oh, I see. It's not my time yet.
We're just finishing our questions.
Oh, I see.
Are there any additional questions? No, you're good, Matt?
So I can speak now?
Well, I guess just one quick question. Did you receive, Ms. Sang, did you receive the CDs that DVS?
I pick up the CD in the office and pay whatever they request. She says she sent it to me. I don't know when she sent it. She did not say, so I don't know.
So you did not receive any CDs in the mail as well?
I did not receive anything. She says this is number 4. I don't know what she sent it to me and when to send it to me. I don't live just in the building, just me. So I don't know where she sent it to and what she addressed. I have no idea.
But you did receive records responded to your 1, 2, and 3.
I did not receive number 4. I did receive over 5,600, so I do not know. As a senior, I don't have the energy or time to go over 5,600 pages and then to identify for the document.
Okay.
And yeah, I already told her that she's able to send you that many pages. She's able. This is an email. She can email or forward it to me. It's not produce something she need to do.
Okay. With no further questions at this time, Ms. Magis will give you 3 minutes if you like to wrap it up, and then Ms. Zhang will do the same for you after Ms. Magis speaks.
So I just want to respond again to what she was saying regarding withholding documents. On August 27, in our response, we stated to her that for items 2, 3, and 4, please see CD files for all correspondence. We have redacted some parts of the records provided to you where we are legally required to do so to protect the privacy of interests of individuals. Redacting information to protect privacy is authorized under California Constitution, Article 1, Section 1, and California Government Code Sections 6245 6254K and 6254C, authorizing the withholding of records, the disclosure of which would constitute an unwarranted invasion of personal privacy. I've informed Ms. Sang multiple times that we have not withheld any documents, and I have done my due diligence with checking in with staff again to ensure that we have not withheld any documents relating to her requests. In regards to item number 4, we sent her a correspondence in October informing her that we would be sending her a CD, and we did. And we further narrowed the request because, as Ms. Sang has mentioned to you, her initial request produced 5,000 pages worth of documents. Our process is in our department when a requester asks for keywords along with specific timelines, we do an email retrieval, and we review those documents and we produce them. They can be duplicates because multiple people have received them in our system, and therefore we produced it to her. She has requested different times to narrow the requests, which we did. We followed up in September. We sent her additional emails. I separated the 4 requests so we could adequately respond to her requests. As you heard her say, her issue now is that there's only 2 documents for item 1 or 5 documents for item 2 or item 3. It's a balancing act for us to produce the documents as is, as we find them, as they're responsive, and ensure that the person requesting receives all the documents they want. What we've done with Ms. Sang is, as she's further narrowed her request multiple times, even until November, which we've been in touch with her about, we further narrowed the 5,000 documents that were initially 536 documents. We narrowed that to 128, and I think that might have been the copy that you guys have received, the task force has received, in addition to further narrowing it to 69 documents. We feel that we have produced all documents to Ms. Sang, and we have been responsive to her for this request in addition to her other requests.
Thank you. Okay, Ms. Sang. You can approach. You have 5 minutes to sort of wrap up your arguments. 3 minutes.
She keeps saying that I request them to narrow down. I did request it once, and then I have never seen that she had to produce. If there are only 6 to 8 emails, it's easy for her to email to me. I requested electronic documents to be provided, and then I have never seen the 6 to 8 emails that she provided to me, and then the documents, she says that she did not redact it. In the email, she said that she did redact it due to the privacy. If it's nothing withheld, you don't even have to tell me you withheld anything. But now she said that I've sent you an email says that I withheld it, I redacted, but I did not do any of those things. Then that's just ridiculous. You tell me that you redacted, you withheld it, now you says, oh, I did not do any of those. I just say that to you, not to me, actually. And as of today, I think that I request the documents. We're talking about number 1, 2, 3. It's not the subject of this complaint nor this hearing. We mentioned that this is just like, it's not that if they don't repeatedly duplicate the documents. That's not that many. I mean, in my opinion, I have never seen the 6, 8 documents she says to produce. So I think that we request the public record, we should get the response to the records obtained. Thank you.
All right, colleagues, how should we dispense with this or move this up? Or do we feel like we have all the information?
I do, and I just, sorry. There we go. just wanted to make sure that Member Martin knows about like what this committee's doing and the process,
Right.
and it's still helpful for me. This is still only the third or fourth time. It may be a good explanation to walk us through what we're supposed to do here and what we, as a committee, do and don't do.
Right, so our charge is we do not adjudicate cases per se. We are to determine jurisdiction, to comply with, and if the records are public, that's primarily to comply with the 45-day rule. And also our other charge is just to make sure that the case is complete, that all the records that we need for our analysis of the case at the full task force level are present and there for our analysis, so that we don't end up wasting time at the full task force going down rabbit holes that we could have avoided. So that if we go down rabbit holes, we're supposed to do that at the committee level. So just to make sure that we have everything in the particular order, if we need evidence from the parties that we feel that we need, we can hold it in committee and not send it up to the full task force. We do not typically make recommendations for finding violations. Our chair is opposed to us doing that in most cases at the moment. So that's a little scenario of what we do. Any questions, Member Martin?
Not at the moment.
Okay. So do we feel like we're prepared to move this case up?
I feel like both sides gave us a lot of helpful information, a lot of their own documentation that gives us, I think, or gives the task force what the task force will need to make a determination on the merits of the complaint. And so, and I do think that these are, broadly speaking, public records, and that the task force has jurisdiction, and I would move that we, as a committee, find jurisdiction. And I don't know if we refer it to the task force, what the proper terminology is, but I think this is ready to go for the task
Refer
force.
is a good word.
And so I would make that motion.
Is there a second?
Second.
Member Kidd has motioned to move that the task force does have jurisdiction and that the records in this matter are public, and to move it up to the full task force without recommendation. Is there public comment on that motion? Seeing no public comment, go ahead and call the roll, Madam Clerk.
Member Kate?
Aye.
Member Kate, aye. Member Hinsey? Chair
Aye.
Hinsey? Member Martin? The motion passes.
All right. Would
I'm
you,
interested to know if you know the 6-8 document he produced it to you. I want you to identify them to me so I know. And I just don't see that any document she produced to you have what she says she produced for number 4. Thank you.
would you go ahead and call the next item?
Item number 6, file number 18081, complaint filed by David Tucker against Bianca Povolina and the Office of Labor Standards Enforcement for allegedly violating Administrative Code Section 6724B2 by failing to respond to a request for litigation documents in a timely and/or complete manner.
Okay, I do see the respondent here.
David Tucker.
Complaint.
Just to let you know, that handouts, I should have gotten this about 5 days ago. The committee has the right to reject it since it's being pushed out now.
Yeah, so our process, typically, we allow materials to get in the package 5 days.
5 business days
Before the hearing?
This is just a summary of my argument. It's
Okay.
just a summary of my argument I'm making here.
Okay.
It's not, that's all. I thought I'm allowed to do that under the rules.
Does
Make a
the-
motion that we accept the document, barring any kind of concerns by the respondent.
Sure.
Is the respondent here? Oh, okay.
As long as he has a copy as well.
Yeah, the respondent, would you like to, give the respondent a copy? So, Mr. Tucker, what we'll do is you'll have 5 minutes to sort of state your case, outline your case, and then we'll give the same for the respondent, and then we'll ask questions, and then each party will have 3 minutes at the end to sort of wrap it up and summarize.
Okay, thank you and good evening. My name is David Tucker. I'm here with Peggy O'Donnell, who's sitting back here in the second row. She's joining me in this effort. I want to first give you a little history. Peggy and I are seeking a copy of the settlement agreement plus related correspondence, etc., involving the conclusion of an administrative review by the OLSC, which is the Office of Labor Standards Enforcement, of some $4.5 million in unpaid health care benefits owed by the Archdiocese of San Francisco under the terms of the Health Care Security Ordinance to some 1,700 of its employees over a period stretching back to 2008 and ending in early 2017. The OLSC investigation of the ASF commenced in 2012 and at the behest of Peggy O'Donnell and remains unresolved to this day. Secondly, there's a reference in the title of this matter to the failure of the OLSC to, quote, respond to a request for litigation documents, unquote. That's an incorrect statement. This is not a request for litigation documents, as the administrative review of the OLSC of unpaid health care benefits under the HCSO does not involve litigation between the OLSC and the Archdiocese, nor are Archdiocese employees suing the ASF under the OLSC administrative action. There's a related class action involving a lawsuit by Archdiocese employees against the Archdiocese, but the OLSC is not a party to this litigation. It has limited its involvement in that litigation to approving a proposed settlement agreement, quote, as to form, unquote. I have that settlement agreement here. If you'd like to see it, I'd be happy to show it to you. Third, the OLSC relies on a so-called, quote, active investigation privilege, unquote, tied to issues of the confidentiality and privacy of parties to the investigation in its effort to turn away our requests for documents. These privacy rules have no application, in my opinion, when the party seeking the settlement agreement is a person who started the OLSC investigation in 2012. That person is Peggy O'Donnell, sitting behind me. Moreover, the OLSC fails to point to any black letter rule in the Sunshine Ordinance where the investigation privilege is set forth. The closest analog may be the litigation material rule in section 67.24b2 of the Sunshine Ordinance, which refers to, quote, when litigation is settled, records of all communications between the department and the adverse party shall be subject to disclosure, including the text and terms of any settlement agreement, unquote. We do not have litigation here, but we do have an investigation that has been settled by a settlement agreement. Here we have something less than litigation, so the rule should be liberally applied. Finally, the big picture view here is that to deny Peggy O'Donnell the document she is seeking is to deny to an Archdiocese employee who is covered by the OLSC administration review and who is also a class member of the class action lawsuit documents she needs to review in order to determine her rights under both proceedings. And that's the big picture here. She needs to seize these documents because she has rights under both the administrative hearing before the OLSC and the class action lawsuit. And unless she has access to all these documents, she cannot determine all her rights under both of those actions.
Are there persons or witnesses to provide facts or evidence on behalf of the complainant? Seeing none, respondent, you please approach and you have 5 minutes.
Thank you. If I may, I'd like to request that Bianca Polovina's name be removed from the complaint. As this is an office-wide policy complaint, it would apply to the entire office. If an individual name is required for the complaint, it's most appropriate that it be mine as Director of the Office of Labor Standards Enforcement. I would appreciate that.
Your name is, sir?
I'm Pat Mulligan. I'm the Director of the Office of Labor Standards Enforcement. And I submitted the response on behalf of the office to the complaint. For context, it's worth noting that this is the first complaint of the Office of Labor Standards Enforcement before the Sunshine Task Force since the inception of our office in over 18 years. And it is, on average, we receive approximately 2 public document requests a week, considerably more right now. For this matter before us, the office has claimed investigative privilege, both in our initial response at the request and also in response to the complaint. This is provided for in California Evidence Code Sections 1040 and Sections 1041, and California Government Code Sections 6254 and 6276. This was an office-wide policy that was developed in consultation with the City Attorney's Office. It's important to protect the integrity of our investigative privilege so that our efforts aren't undermined both in investigation and in settlement negotiation by business interests, which we've had in the past. To the specifics of this case, we have preliminary terms, but they're not final. If they were final, I would not be here before you today. We would have disclosed all the documents, as we do in all other cases. This is a large, complicated, and sensitive case with polarizing elements. It is complicated further because of the parallel class action lawsuit. The terms, though tentative, require approval of a judge. That may happen as soon as the next 2 weeks. At least some sort of preliminary or tentative approval. So hopefully this will be a resolved matter shortly. Thank you.
Okay, questions, colleagues?
I've got just a couple of questions about the settlement agreement, and just to make sure, has counsel for the class plaintiffs seen the OLSC settlement agreement?
They are not party to it because this was the employer, large settlements. This is a multi-million-dollar settlement, as the complainant has indicated. It is difficult to reach those frequently. The employer has indicated they want a universal settlement, which is not uncommon in this type of case where there's parallel litigation. For us, for basically expediency, for trying to resolve this matter and get restitution to workers, we're amenable to it. This is exceptional for our office. So these are part of the terms, and it's a requirement that a judge approve it. So we're potentially weeks out from this.
I guess I'm just trying to get an understanding of maybe how many people outside of OLSC and the Archdiocese have seen that settlement agreement. And if, especially, if class counsel has seen it, and they're obviously their settlement agreement and their motion for the determination of their settlement has references. It obviously doesn't mention any of the details.
I don't believe we have disclosed this to the class counsel, but because there's kind of joint settlement terms, the class case, not to get into details, actually has larger breadth than our investigation, so there was overlap around it. I think they're probably aware of the terms because there was consistency in it.
Right.
Yeah, to your point, and for those of you familiar, as part of the settlement, as part of, I think, before the judge, notice will have to go out to the class on this. I don't believe that's the case yet.
Right. And do you know, I think just one more, maybe two more questions. I was looking at the docket and I see that there's another, they're going to go back before Judge Carnow here in a week, right at about a week, and more supplemental briefing or some kind of evidence. Do you know what's going on with that?
Again, I'm not tracking it because we're not actually party to it.
Right.
But I do know if it is unresolved, we are back to negotiation. And we have to then carve out our own terms independent of this.
And just to confirm, and I think this was in your submission, and you may have even already said it, once the court, blesses the settlement, the settlement agreement from your office then is public, and you have no issues turning that over.
As with all of the hundreds of other cases that we've resolved.
So there is no final approved settlement.
Carol, use the mic.
So there's no final approved settlement at the moment.
We have tentative terms that are contingent on this judge's approval. If the judge doesn't approve, then we have to renegotiate.
And the judge has not approved it.
I believe, and again, I'm kind of loosely tracking it, I think the judge receives documents. In fact, the complainant might have more knowledge about this. I think December 3rd, and then potentially I think within a week we'll render some decision.
So is the Archdiocese trying to land both settlements at the same time?
That's their plan. I can't speak for them. I would imagine, which is common for a lot of our cases, if there is parallel litigation, they'll want to settle any outstanding matters.
Yeah.
Yeah, they don't want somebody else coming back with a bite afterwards.
But neither knows the terms of the other settlement except the Archdiocese.
Yes.
Right? So they know yours, they know the class action. They don't want it shared.
Excuse me, we have some shared information agreement with the class action case because they were performing earlier on and again, I don't want to get into too much detail, a forensic audit. We felt that there could be some benefit around our parallel audit regarding the employer.
Just to rephrase this one other way, you guys have come to an agreement and the judge has not approved it yet.
Correct.
Okay.
One more, sorry. And the settlement agreement between your office and the Archdiocese is contingent on the court's approval of the submitted settlement, not the closing of objections for class period and things like that. It's on the court's approval of the class settlement.
The class settlement terms. That's my understanding. And again, I don't know. Yeah. It's probably best not to quote me on those terms.
That one I think would be an issue going to their concerns about during the class period if they feel like they need information to assess their reasons or lack thereof for objecting to the class terms, the class settlement terms, that they would, I don't know all the reasons why, and we're probably getting a little further afield into the merits that we're not going to really kind of deal with today,
If I can offer, it's my understanding that we are not party to the class. I'm not clear that the complainant is either. That the class, that at the time that the judge kind of, I guess, acknowledge or renders an opinion, then the information is then disseminated to all of the individuals in the class. So it's not like we're any obstacle to that. They would all be made aware of.
But
the
upon
terms.
that, is it your all's position that upon that move by the court, that then your settlement agreement can be disseminated to whoever files a request for it?
Procedurally, it gets into procedurally, I believe that the information is disseminated to the class, and then there is a final decision by the judge to accept the terms, because there is a period then for the class to contest it.
So I guess the rationale that your office has for holding back on the settlement, your settlement agreement, is not contingent on preliminary approval of the court, but final approval of the class settlement.
Yes.
final approval after the class period,
If
objection period is
if
over.
it's not approved, we're back to square one, and we have to then renegotiate terms independent of this.
Okay.
Yeah, and there's a lot of, information there related to the case and around a lot of negotiations that it would be difficult to negotiate this matter in the public. I'm sure people could appreciate that. It's a polarizing case. We're dealing with a longstanding religious institution where people have strong opinions.
I think that I've got what I need for today's purposes anyway, I think, personally.
All right. Respondent, Mr. What was your name?
Tucker?
Sorry. Respondent, you have 3 minutes to.
He's the complainant.
The respondent has his time first for rebuttals. If there are no other questions for rebuttals and wrap ups, the respondent has his time first, and then because the complainant always has the last word. So
I'm not sure I understood that.
We need the respondent to make his final words. So you will speak after the respondent.
after the respondent,
You'll have the last word is basically it.
Okay.
So yeah,
That's
I guess
nice.
if Mr. Mulligan has a rebuttal, right? He can now do
Yeah, he can
his
now
3
do
minutes.
his
If you
3
have anything
minutes,
else to
yeah.
add, and then you would have the last word.
Right.
Okay. First of all,
No,
Mr. Mullen
you need Mr. Mulligan to speak.
Yeah,
That's his rebuttal, and then you'll be the last to speak.
Okay. Oh, I'm sorry. So I provide rebuttal?
Yeah.
Okay.
If you have one, you can do it at this time.
Yeah, I don't think I have much more to add. I think I've cited, I think most of it's in the file. We've cited investigative privilege. I understand the nuances of this case. This is exceptional for our office, but I, want to serve to protect investigative privilege because it's important for our office. Thank you.
Now you can go for 3 minutes, Mr. Tucker.
so my turn?
Yeah.
We are here because Peggy O'Donnell and I sat in the office of class counsel about a month ago and learned for the first time that the settlement agreement involving the administration action had been inked by all the parties. That came as a shock to us. So we immediately asked the OLSC for a copy of that agreement because it, number one, I don't think it should be inked and signed and executed before the class action was adjudicated. But it was, so we asked for a copy of it. We refused that by the OLSC, and that's why we are here. So I don't think it's true that the administration action is pending in terms of settlement. I was told by class counsel that it was signed and inked and final. Bianca also confirmed that to me in an email she sent to me in the course of getting to this point, that it had been signed and it was in that sense settled. She said it might be opened up depending on what might happen on the class action side, but that the parties to that action, including the Archdiocese and the city, had signed it. We have, in the last few days, Peggy and I have been in touch with class counsel and the court. I sent a 6-page letter to the court about 4 days ago. As far as I know, the court has never seen the settlement agreement in the administration action. I'm not sure class counsel has seen it. I have asked questions of him in detail about what's in that agreement. He has not responded to those questions. I asked the court, when the court gets back to class counsel before the December 3rd meeting, to ask for all kinds of documents from both sides. A copy of the settlement agreement we're talking about now, which the court I don't think has seen, copies of the spreadsheets involving the determinations made by the by class counsel in terms of coming to the $4.5 million number, all the numbers in the spreadsheets that should be a part of the administration settlement agreement. There should be a schedule, a spreadsheet showing the names of all the employees and the dollar amounts. We need to compare, and Peggy and I are happy to do this, all those numbers and see if they come up with something approaching fairness. We think there's no fairness here for 1,700 employees. And it does not matter to us that the employer here is a religious institution that has a big footprint in this city. 1,700 employees are owed benefits, and we are convinced that they're not being treated fairly, as between the OLSC action and the class action. We believe that class action will never be settled. We were asking the courts to dismiss it and to bring all the employees under the class action back into the jurisdiction of the OLSC, where they can finally find something that we think is fair for everybody. So I have a very different view.
All right, sir.
Mr. Tucker,
Wrap it
you
up.
need to wrap it up.
Wrap it
You
up.
passed your 3
That's
minute
it.
time.
That's it.
Thank you. All right, colleagues, how should we dispense with this case for today? Thoughts?
I think factually, I think we got what we need for the task force to make a determination. And I
Right.
think there are some, legal, the legal issues are, I think, the bigger question here, the scope of the privilege, investigatory privilege, the legal issues that would be good for the city attorney's office, their representative to help us out with. But I think in terms of the factual things that we're looking at today, I think this is fairly teed up. A potential, there would be some different facts will roll out in the coming weeks, it looks like, on the class action. But it probably won't be resolved finally until the task force hears this, assuming it goes up to the task force. And I'm not sure that whatever happens with the class action settlement changes the legal questions. I do think in terms of determining whether there's a violation of the Sunshine Ordinance or the Public Records Act, I think this is probably ready. And I would find that this is a public record. I would move that that the committee find that this is a public record, that we have jurisdiction, and that we refer it to the full task force for its consideration.
Without recommendation? Without a recommendation?
Yes, it's
Are
motion.
there issues that you would like the city attorney to look, that you think it would be helpful for the city attorney to look into for us prior to this going forward? Because we can include that instruction in the motion.
Yeah, no, I think it would be helpful. I know the memo that we've got presently just kind of talks very broadly about one of the statutes that governs public records requests. It would be good to have a better explanation of the privileges that the respondent is claiming and how they apply to a contingent settlement agreement.
Makes sense, Cheryl? Does that make sense did he catch that, basically, to include in the motion instructions for city attorney? Yeah.
Right, the scope of the privilege as it
And
applies.
litigation material.
Right, and hopefully with the materials that are available in our materials and that request, however well worded it was or was not, I think that they ought to be able to.
Are you making the motion?
Yep.
Yeah. All right, do I have a second?
Yep.
Second by Martin. Okay, great.
Is there public comment on that motion? Seeing no public comment, Madam Clerk, would you please call the roll?
Member Kate?
Aye.
Member Kate, aye. Member Martin?
Aye.
Member Martin, aye. Chair Hensy?
Aye.
Chair Hensy, aye. The motion passes.
Great. Let's now return to the first case. I'm going to ask one more time, is the complainant whose name is Gutierrez? Are you here? No? Okay, then, in this case, typically what we do is we, get in contact with we table the case for the moment, and we get in contact with the complaint. Our staff gets in contact with the complainant and
We'll do that
basically
first thing tomorrow morning.
Sees what their intentions are with the case, and if they say they want to proceed,
We'll reschedule.
we'll reschedule. So I should ask for a motion probably for a continuance. Do I continue or table? I'll continue, yeah. So do I have a motion to continue?
So move.
Yeah.
Okay. So moved in a second by member Warren. Okay. Do I need to call the roll on that or no? You can go ahead.
We'll call the roll. We'll call the roll. One moment. Chair Hensy?
Aye.
Chair Hensy, aye. Member Kate?
Aye.
Member Kate, aye. Member Martin?
Aye.
The motion to continue passes.
All right. Would you please call the next item?
Item number 8, adjournment.
All right.
Motion to adjourn.
To adjourn.
Motion to adjourn.
All right. Thank you, everyone.
Thanks. Sorry I was late.
No, it's all right. I'd only been here about 10 minutes, so I was late myself.
Yep.
You want to, sorry I was late.
No problem. We can start with 2 members, so it wasn't too bad.
Yeah.
I know. I figured it got everyone.